hold that particular person. And I think it's also been termed as, would this allow the prosecution to proceed if relief is granted? In Ms. Hammond's case, and even in Ms. Couch's case, I think that it's undisputed that the prosecution will proceed. Trial court still has the authority to proceed on the case, regardless of what the outcome of the argument is, because there is an uncontested portion of that. Now, when we talk about, all right, we talk about the three rationales for pretrial writ and cognizability under Smith, challenging the state's power to restrain them at all. And I think that's really what the heart of these cases go to, is does the state have the power to restrain Ms. Hammonds? And they're not contesting that we don't have the power to restrain her at all. We absolutely do under the uncontested count 2 of the indictment. Now,
they were making an argument, though, that Chapter 11 in this context doesn't require complete restraint, but only partial restraint. And I'm wondering, can you address that argument that was brought up during today's case?
I don't think Chapter 11 has ever been held to only allow for partial restraint. We talk for release from partial restraint. I haven't found a case that has held that only partial restraint would allow habeas to be brought up, outside of maybe Ex parte Watkins, which was the slight exception under the double jeopardy collateral estoppel claim. And in there, with double jeopardy being the right of double jeopardy for vindication is not to actually be put to trial again. And that specifically was dealing with sudden passion. It was the right not to face a first degree and be retried over an issue that had already been decided adversely to the state. So outside of the double jeopardy context, in Watkins, I couldn't find anything in my research where it allowed for, well, partial restraint of an indictment to be cognizable or allowed even under any of the current Chapter 11. And I think when talking about pretrial writs and when looking at what it's designed to do, it's designed to stop a trial. It's not designed, pretrial writs are never designed to facilitate trial, they're always designed to stop trial and bar the proceedings. But if we're always going to get to the proceedings, and in these cases, in order to have multiple counts, under the law, they have to be in the same criminal episode. And so a prosecutor should not be charging unconnected criminal offenses. Although that may happen, that would subject it, one, to automatic, to requests for severance, motions to quash. There's a lot of remedies that a defendant would have in order to counteract all that. All the prosecutorial abuses that Mr. Bennett brought up, talking about that the state could do this, the state could do this. Well, there's remedies the defense has to protect against that.
Well, counsel, when was her bond set before the DA counts were added?
Yes, the bond was set. It's not in the habeas records. I don't want to go too far out of that, but there was a bond originally set when she was arrested. And that was before even the original indictment. She was indicted, and then there was a superseding indictment which added the 2 counts dealing with the serious mental injury that she's challenging. But there was never a subsequent bond set in the case. So she's only on 1 bond in this case.
Okay.
So it's that single restraint.
Is there really no, I mean, I recall, I can't remember who wrote it, but someone was talking about the bond situation, right, being different in different counties.
Yeah.
And like where sometimes judges might require separate bonds for all the different charges in an indictment. Other counties, you just have to have 1 bond. Is there really no statutory sort of requirement that answers that question?
I haven't found any specific statutory requirement dealing with how many bonds have to be in a multi-count indictment. I think it varies a lot, and I think it varies within our county as well. I do all of our bond forfeitures as well, so I'm very familiar with that. And the way I have typically seen done, it depends on what they're arrested on. If they're arrested on multiple offenses arising out of the same criminal episode, typically there's a separate bond for each offense. But if, in this case, if there's charges added after the fact by the DA's office through the grand jury, then there would not typically be a separate bond for those unless the judge found the bond insufficient or decided, which he would have the authority to do.
So in this case, you just had the bond when she was originally arrested. Was that pre-indictment?
Yes, Your Honor. Or, yes, Judge.
And then she was charged with subsequent counts in the indictment.
She was charged with one count in the first indictment,
Right.
and then subsequent counts in the superseding indictment.
Okay. And there were no additional bonds imposed on the new counts?
That's correct. And so, and that's one of the arguments that Ms. Hammonds has made in her brief to this court, is that it's the bond that is the restraint. She says that on page 17 of her brief, that being on bond is the restraint of liberty Hammonds is currently suffering. Well, if the restraint on liberty is that bond, and there's only a single bond, then she cannot challenge the restraint unless she challenges everything within the indictment, because there's just that single bond. And then when talking about the harm or prejudice of not allowing these cases to be challenged pretrial, these two counts, she talks about multiple complainants, there's different complainants in each count, and that would cause prejudice to her. Well, that's starting to look more at the facts of the case, which then is this more, I'm not saying it's an as-applied challenge, but if you have to delve into the facts of the case, that's getting away from facial challenges and cognizability, when we just have to look at the face of the indictment and not really the reason behind that.
So are you saying she's not making a facial challenge?
I'm saying she is making a facial challenge. I'm saying her reasoning behind why it would be prejudicial is looking more into the facts.
Requires a
So
balance.
that's why it should be, the rule should be, you have to challenge the entire indictment. In this case, yeah, the fact that she does have that severance right would vitiate against any of the prejudice that she's raising in the brief as to that as well. So she could choose to sever the case, potentially get to raise it that way. That would still be an undecided issue of whether if the
You
case
wouldn't object to that, is that what you're saying?
the severance.
Right.
I could
No.
not object.
No, I'm saying, would you object to her being able to bring this kind of a habeas if it was severed?
I don't think so, because I think the state's position here is that at a minimum, it has to be the entire indictment or the prosecution pending in front of the court. A severance would create a different criminal action under Chapter 3 of the Penal Code. So it would be a wholly separate criminal action. And I think if it's a separate criminal action, you have the ability to raise that pretrial.
Mr. Bennett's brief breaks it down into all these different possible scenarios, you know, 2 counties, 2 charges, 1 county, 2 charges,
And I think
1 indictment, 2 charges.
And I cited in a footnote, I believe, I think it's ex parte joiner. It's an older case where they held that it was not cognizable because the person had already been convicted on another offense and was being detained. That, by no means, is the state arguing that that is proper. If indictments are pending in 2 separate counties, the state's position is that you absolutely could raise pretrial habeas as to one of the indictments in the county because they are not the same prosecution. If the cases are severed, I think the same rationale would be there of they're not the same prosecution. Now, there would be the issue in Bashaev if the cases are consolidated, if it's multiple indictments consolidated, but again, that's not before this court, but that would be a potential issue for later. But if they were severed, then it would be a different prosecution. Most likely, there would have to be a new bond issued, which would be the additional restraint on the new case that was severed out. So there are ways for a defendant to get that, but the defendant has to make that decision because once it gets severed, then it's subject to being stacked or consecutive sentences as opposed to now where they would have to all run concurrent. So it's really a defendant's election on what they choose to do. They could also choose to bring a motion to quash or objection during trial, and then raise it post-trial. So the defendant has a lot of different options here. So they're not being stuck of this is their only option and they're not going to have any ability to challenge or raise this at any point in the future. When looking at the court's language dealing with habeas, we talk about that habeas is not available to test the sufficiency of an indictment or challenge, and that's really dealing with sufficiency, but the overall principle, I think, comes down to whether a court has that power to proceed. And I keep going back to the power to proceed because I think that's the most important thing to look at is what is the remedy that's going to be given if the claim was meritorious. In this case, it would be those 2 counts would be dismissed or stricken from the record, but the trial court would still have the power to proceed. And kind of going to Judge Yuri's question about raising these challenges pre-trial and the amendment of the rules, I know a defendant cannot raise a denial of a motion to quash pretrial, but the state can. So if the defendant does successfully quash an indictment, the legislature said the state has the ability to bring that up. And that's, I believe, 44.01. So
Ordinarily, because it stops the prosecution, but not necessarily in your favor, is that it may apply even if it stops it a little bit and not completely.
absolutely, and I think it has to be that way because the state would not have the ability to appeal post-trial on that issue. And because we wouldn't have the ability to appeal post-trial on that issue, the legislature has given us the ability to appeal that pretrial. But since the defense can, there's no corresponding need for a defendant to raise that pretrial.
You know, there are consequences to the defendant, though. I mean, they have to prepare for trial now on an offense that may arguably be an unconstitutional offense. So, I mean, that's extra work. They have to spend extra money. Their lawyer has to spend extra time. They may have to call extra witnesses. There are costs to the system on the defense side as well.
There are absolutely always going to be costs to the system, but I think and I see I'm just almost out of time, but I'll finish answering your question. The issue there, since all of these are out of the same criminal transaction, I don't think it's as much of a cost because all the facts are still the same, the issues are the same, although the indictment's going to be different. Everything is going to come in the same way. It's merely just what the jury is going to be deciding at the end. So I don't think it's as big of a cost as if these were two unrelated, like if we were charging a DWI from one incident and a capital murder from a completely different incident. Obviously, that would raise those issues, and I don't think that would be proper to charge together. But if they all arise out of the same criminal episode or criminal incident, I don't think that would be much of a concern. If there are no more questions,
Thank you, counsel.
thank you.
May it please the court. My name is Andrea Jacobs, and I'm here on behalf of Tarrant County for Ex parte Couch, the appellee.
Do you agree with your co-counsel that the state doesn't have any problem with us saying that if you're talking about separate charging instruments entirely, that it's a non-issue, that the state concedes that you can address these things in a pretrial habeas as long as they're separate charging instruments?
Yes, I agree. And that's where we're in a unique situation here, where actually Mr. Price has made a lot of my arguments for me. So, but I would like to point out that we do kind of differ on that unit of restraint. I think it has to be quantifiable, and indictment number is a way to quantify that. So you have that unit of restraint by indictment number. Also, I think by bond. I agree that bond is a restraint. So if you have multiple counts in one indictment and you have multiple bonds, then they should be able to say, of course, we know writs, applicant has the burden. They have to show that if they were to get relief, that they would be, immediately released. If they show that they're going to be off a bond if they get relief, then I believe it makes it cognizable. So yes, I do agree that separate charges, if you have 3 counts, but they're now, another county does it in 3 indictments, then yes, they should all be, you can all independently attack those because it's quantifiable by indictment number or by bond number. You can actually say, here's that unit of restraint.
I guess where I get a little confused in this is, but you just have a bond on one of the counts, right? And then you added 2 counts at a later time?
Oh, well, Ms. Couch only has 1 count.
Okay.
But she has 4 indictments. There's been re-indictments, and I'm unclear as to which, how many bonds there are. I thought there was 1 on each, but I didn't realize I don't know. But the point is that she's only attacking part of a count in each indictment. So she has 1 count, but she has 5 words in that count that she is attacking. Habeas is an extraordinary remedy, and so it requires extraordinary circumstances. If you look at habeas and you look at the laws and the jurisprudence of habeas, it really boils down to only 2 issues. Historically, we talk about release because it was a way to get out. All the writs are extraordinary. And here we have the way to, if I'm confined and I want immediate release, the habeas corpus was the way. We joke that habeas corpus is like the Jerry Maguire, show me the money. It's to show me the body. And so it's all about release. But then this court decided, as they should, that in Texas, we should have a narrow exception. And that is those claims where if I go to trial, then I have no remedy. Double jeopardy, the right not to be tried. You shouldn't have to be tried and violate that right to raise double jeopardy at the end. So we don't look at immediate release for that. Bail bond, bond conditions, things like that. Well, if I get convicted, I go to trial, that goes away. It's now moot.
What about my earlier question to other counsel here that, what is the right that you have to avoid anything with regard to an unconstitutional law? Do you have a right to, I know you have, I presume that you have a right to avoid conviction, but I'm wondering about this concept of, do you have a right to avoid a trial on that where you would then, if convicted, have a subsequent right to appeal the decision?
The important point is here, there's the presumption that the statute is constitutional. It hasn't been found unconstitutional. I believe if it's found unconstitutional prior, then you have a right not to be tried on an unconstitutional statute. But I believe because the statute is presumed constitutional, then it's going to be later, it can be later down the road. And especially with a facial constitutional challenge and an indictment, motion to quash the indictment. That is the remedy here. That is what they can file, a pretrial motion to quash the indictment. And then with Ms. Couch, if she's only attacking those 5 words, she can file a motion to partially quash.
I mean, what if there was a law that said you can't, it's a crime to send a letter to the President of the United States asking him to take some presidential action, right? Veto something, right? And, I mean, do you have to go to trial on that? Really? Before we could say that violates the First Amendment, would that require a full-blown trial, calling all the witnesses to see, the postman to say, yeah, there was a stamp affixed to it, had her DNA on it? Do you have to go all the way through trial before we can say, nah, this is unconstitutional?
There's also another part about habeas. It's on a separate track with the trial. And so even if they have a pretrial and the judge decides it's not facially unconstitutional and it goes to appeal, they can still be tried. So it doesn't stop the trial to have that appeal. So they could still be tried and then, be convicted on that.
Counsel, what if the state includes a jeopardy barred count?
That
Instead
one,
of- you've got an indictment with one valid count, you've got one that's jeopardy barred. If he doesn't object, they're now forced to go to trial on something that they have an absolute right not to go to trial on.
well, double jeopardy is one of the exceptions because that is, you're right, the not to be tried.
But it's
So-
still in the indictment, it's the same issue.
Well, no, because this way, double jeopardy doesn't require immediate release. So you can litigate that double jeopardy in a pretrial habeas, even if you wouldn't be immediately released if given granted relief.
But you wouldn't be able to appeal the indictment.
You could appeal okay, double
Right,
jeopardy
right.
also stays the proceedings. So if you're saying, if I understand, you file the motion, the pretrial, habeas corpus alleging double jeopardy violation. And the trial court denies it, and then you appeal it. Double jeopardy is the one exception where if it's not frivolous on its face, a stay is appropriate. Because it's the right not to be tried. But every other one, it's more of a discretionary decision whether to stay those proceedings.
Why have an exception for double jeopardy but not for facial unconstitutional claims?
Well, I think there's 2 reasons. One, double jeopardy, again, is very clear the right to be tried, not to be tried, right? So the right is in the pretrial, and it goes away. You've now violated that. But more importantly, it's double jeopardy on its face, right? You look at it and you see it, okay, that is double jeopardy. That is a problem. And but with facial constitutional challenges, unless it's already been found unconstitutional, we have to do a lot of digging and it's not on its face. You've got to figure it out. You actually have to litigate that. And so I think it's more that if it's, of course, already been found unconstitutional, then the right to be tried. I think then if you file a motion to quash and the judge denies it, I believe a mandamus is probably the proper thing on that. So if it had been already found unconstitutional, then they could still file the motion to quash. If it hasn't been found unconstitutional, file the motion to quash. If convicted, they can appeal it. It's a de novo review. And if the appellate court then decides that it was unconstitutional, facially unconstitutional, then they go back to that indictment and they get their relief. So it is,
I'm asking more questions.
it is a remedy. And that's the issue here, is that for habeas, it's either I'm going to get immediate release or I'm going to lose my remedy. And for motion to quash the indictment, you have a remedy. It's not immediate, but it's not required to be immediate. It just has to, it has to be available. And so here we go, that yes, you have it. It's going to be there. Now, we also have other pretrial motions are just like that. To say that a motion to quash, that, well, it's unfair because they have to wait till convicted. Well, you got motions to suppress. All pretrial motions, you have to wait until the end to appeal that issue.
Well,
What about Mr. Bennett's argument that it's a general verdict and you're not going to know what the jury convicted on?
So it's very interesting, thank you, that it depends on how they raise it, right? They raise it on appeal. If they raise a facial constitutional challenge just on itself, which is cognizable on appeal, that probably ultimately the Court of Appeals will say, you know what, we can sever that so it's not facially unconstitutional. We're not going to go there. However, the motion to quash the indictment, that actually bases it on the motion to quash decision, not on what happened at trial. It is the appellate court reviewing the trial court's decision, de novo, about that motion to quash. So it is still alive. So as we said, there's no exception here. So we must look at immediate release. And I believe that's a quantifiable unit of restraint. And what do I mean by that? I believe Tarrant County's position is that proof of immediate release requires that it be actual confinement and not abstract. Historically, with the writ of habeas corpus, because it's extraordinary, we do have case law that says, I was convicted in this county, and now I'm attacking it over another county over here, and the courts have said, if you get released over here, you're still going to be confined under this sentence, we're not getting involved. And that's, so it's run the gamut on what immediate release means and how much confinement. And so what we really need to do is narrow and decide, and we've asked you to decide what the unit of restraint should be. Now it's more broad, but still it's not abstract. In Ms. Couch's case, we're talking about 5 words. We're talking about 1 count and a manner and means, or another. Assume for a moment that it does multiple charges. Well, it doesn't, and we're looking at only 1 count. We're still looking at 1 indictment. So my argument is the same whether you want to treat those manner and means as multiple charges, and it should have been multiple counts. If it was improperly pled, motion to quash the indictment is the proper way to take care of that. So the quantifiable unit of restraint should be something that on paper you're going to be released. If you take the 5 words away and you sever it, she still has 1 count. She still has 1 indictment. She still has 1 bond. Ms. Hammonds has 3 counts. You attack 2 counts, you still have 1 count, 1 indictment, 1 bond. There's no quantifiable way to, there's no way to quantify that release and that restraint. So the unit of restraint should be something that you are able, on paper, hey, look, they got some relief. They're going to get out. They're going to lose, the bond's going to go away. The state can't proceed on this indictment. The trial court has no power over them. And the problem is, in Texas, it can't be a one-size-fits-all rule. It can't be, because it has to be case by case, because every county does do it differently. In Tarrant County, we do, I believe like McLennan County, it sounds like, 1 indictment, and if you are charged with, like you get arrested on 1 offense, and then you're later indicted, but we add some, example, aggravated assault with a deadly weapon. Someone gets arrested on that. While the state is looking at it and they get they're looking for indictment purposes, they realize unlawful possession of a firearm could be attached. So they attach that in the indictment. There's only going to be 1 bond. If the officer pulls him over, gets the aggravated assault with a deadly weapon, charges him with that, and knows from the mobile data unit that he's also a felon and throws that unlawful possession of firearm there, there'll be 2 bonds, but 1 indictment. So I believe a good way to look at it is, yes, 1 indictment if there's 1 bond. But if there are 3 bonds, then I believe we should look at it that way.
I know this is going to be a little random, and it's not addressing that statement you just made to us, but there's another thing that I'm curious about. and that is if somebody is under indictment in 2 different counties, are they being restrained by the state of Texas in both cases, or are they being restrained by separate counties at the same time? Do you follow?
Right, yes, and I believe that, yes, the state of Texas, this big unit is restraining them, but it's by county. I would treat it separately. I wouldn't say, I'm sorry, but, again, the quantifying unit could be the indictment number, the bond number. If there's gonna be 2 bonds, if there's gonna be 2 indictments, we treat them separately.
Okay, thank you.
The bar shouldn't be too high. I agree with that. But it should still require some sort of actual release, not an abstract concept. As I said, it's not one size fits all. It does need to be case by case. When doing that, we're looking at this unit of restraint. And I know with Ms. Couch, she's got the five words, and I just believe that even if those go away, we don't have immediate release. Extraordinary remedies require extraordinary circumstances, and we do not have extraordinary circumstances here. Therefore, Tarrant County prays that this court finds that her claims are not cognizable, because even if given the relief she requests, she would not result in immediate release. Thank you.
Thank you, counsel. May it please the court, I want to start real quick just by making sure that Judge Keel isn't worried that I'm raising an as-applied challenge. The 2 complainants listed are on the face of the indictment, and so you can clearly see without any necessity of record development that we're talking about 2 complainants. So I don't think there's any way that this is an as-applied challenge. Next, talking about the right to severance, I was just flipping through to see if I missed a part of the briefing where any of us really meaningfully talked about severance, and I don't think anybody really did. And so if that's important to the court, I think the court may want to consider having us do some additional briefing on that. My concern, so let's say Mr. Price is right and I'm wrong, I'm entitled to sever and it's not discretionary like I think it is. So we're saying if I go through that procedural step, this kind of reminds me a little bit about the conversation y'all had in Reed with the improper accumulation order and talking about the remedies for how you get to the same outcome and the differences y'all had in which path should be taken. That's kind of what this reminds me of. So if I go and I sever, then nobody has a problem with me raising my challenge just because we've got a ministerial difference and a different instrument. That, like, what difference does that make? So then if I go do that, if I lose here and I go and I do that and we're back up, I think, again, that's the problem that y'all contemplated with the remedy distinction in Reed, which is we're all just trying to get to the same thing. And so are we really going to make some kind of merits distinction just because we have 2 separate cause numbers? Because of the jurisdiction conversation you just heard, I think that makes no sense. And I will say just, it's not a meaningful distinction with the bond conversation Mr. Price gave you, but to illustrate the point in jurisdictional difference, Ms. Hammonds was arrested and bonded out pre-indictment. Her first indictment, she was actually re-arrested. We used to have a local practice with post-indictment bonds where you'd have to go and post a second one. That is not clear in the record. Y'all may see that I actually did a first amended brief. I took that out because I was like, it's not in there, so I shouldn't talk about it. So that's why I had a first amended brief. But that little step, so she actually had a post-indictment bond. Mr. Price is correct that when there was a superseding, there does not appear to have been any additional increase on her behalf. But like he said, that's very judge dependent. That's going to be something if a judge wanted to find her bond insufficient because now there's a first degree allegation, he would have been completely free to do so. And so I think, and I would implore the court to not start to get into these ministerial distinctions when we're trying to set this understanding of what does immediate release matter to the cognizability of a facial challenge. If we start getting into these ministerial distinctions, it's...
I'm getting thrown by your use of the word ministerial. I'm wondering if you're meaning like bureaucratic as opposed to ministerial, because ministerial is a word we throw around when we're talking about when you might be entitled to relief on mandamus.
Yes,
I don't know if you're using it in the same context or...
Administrative
Okay, thanks.
So yes, some some administrative choice in charging that is completely discretionary. That's not like a Black's Law Dictionary definition, but for conversation purposes. And so I think that there is going to be more problems than not if we don't just solve, I think, what is the basic question, which is immediate release, all or some. And I think the simpler we keep it, the easier it will be for everybody. But if we do want to have a conversation about severance, I think that y'all may want us to do some additional briefing, because I don't think any of us thoroughly addressed that. And unless nobody has any other questions, I will return my time.
Thank you, counsel.
Thank you.
Really interesting law geek question. If you look at Article 11.32 of Texas Code of Criminal Procedure, it says that once the writ is returned, the court no longer has jurisdiction under the instrument that's being challenged. There's a case that this court decided, I don't know, 100 years ago, called Kirby, K-E-A-R-B-Y. It's 34 Southwest 962, where this court addressed the issue of it had issued the writ of habeas corpus, it had been returned, and it was a contempt case. The trial court then held the guy in contempt again, and Mr. Kirby came back to this court, and this court said, no, trial court, you can't do that. You don't have jurisdiction after the writ has been issued. This hasn't been, 11.32 hasn't been closely looked at by this court, or by any court, frankly, for the purpose of deciding whether the trial court continues to have some jurisdiction, as Ms. Jacobs believes, to try the case after the writ is returned. 11.32 and Kirby stand for the proposition that the trial court does not have that jurisdiction. I'll do my best to bring that issue to this court in another case, but it's not present here. I just wanted to put a big thumbtack in it because it's a really interesting issue. A void statute is void ab initio. So if an indictment alleges a void statute, it's not an indictment at all if it's raised, right? A content-based restriction is presumptively unconstitutional. So while a statute generally is presumptively constitutional, if you look at the statute and say, oh, that's a content-based restriction, it's a restriction on what you can say, it's a restriction on what you can think, then it's presumptively unconstitutional. Counts are quantifiable. So Ms. Jacobs says it should be quantifiable. Okay, indictments are quantifiable, bonds are quantifiable, counts are quantifiable. You can count number, literally counts are countable, quantifiable. So here Ms. Jacobs wants to shoehorn counts into some category other than the quantifiable. Well, counts are quantifiable. And we really should be charged in 2 counts because these are separate offenses as defined by separate elements. If they were manner and means, then the state would be saying, by doing this, by doing that. And in fact, if you look at our indictment, the most recent indictment in our case, they add manner and means at the end, by withdrawing funds in cash in the amount of $30,000 and so forth. That's a manner and means, by. It's something that they didn't have to allege. It's something that they don't have to prove at trial because it's a non-statutory manner and means. But that's a good example of what manner and means are as opposed to an element. It purports to describe the element of financing or intending to finance. Different administrative policies should not control justiciability. What Ms. Jacobs says is true. Different counties have different policies here. Well, the answer to that is to treat all of those policies the same. And the way to treat all of those the same is to treat them so that the state can't play games to eliminate justiciability. Harris County can't decide to start filing separate counts instead of separate indictments to defeat justiciability. Tarrant County can't decide in a case that involves a suspect statute, well, we're just going to set one bond because that will defeat justiciability, whereas multiple bonds would not defeat justiciability.
Well,
The habeas...
Would your claim be vindicated, though, in a motion to quash?
So it wouldn't be, our right not to be prosecuted under a void statute, our right to be prosecuted only for a crime wouldn't be vindicated by a motion to quash unless, of course, the motion to quash were granted. But then if the motion to quash were denied, then our right wouldn't be vindicated at all because we would be tried for something that in our contention is not a crime. Also, well, no, that's the thing. I'd also note that as far as severance or a motion to quash, we don't really have a way to force the trial court to rule on that before trial. Habeas, the court is required to have a hearing and to rule as soon as possible.
Why shouldn't we then say that as a precondition, since, I mean, you agree, it's two-part, I'm sorry.
Okay.
You agree that habeas is an extraordinary remedy?
Yes.
Right? And if you have a remedy available in the trial court in the form of a motion to quash, why shouldn't we say something like, well, why didn't you try that first? Maybe you should try that first before seeking the extraordinary remedy, because it's kind of like, is there an adequate remedy at law, right? In other extraordinary contexts. And, I mean, there is this opportunity to file a motion for quash. Who knows, maybe the trial judge will be on your side. And then the state might be in the position of appealing the question of the constitutionality of the statute rather than the defense.
I don't think adequate remedy at law hinges on us relying on the trial court to grant us relief. I think adequate remedy at law has to presume that we're going to have to fight every step of the way. And there is no adequate remedy at law if our motion is denied and then we have to go to trial in order to appeal that.
My point is, I wonder whether you know whether it would be denied in the trial court. We're expending a lot of judicial resources at the high court now with 9 judges
Yeah,
considering.
actually, I do know the answer to that,
Okay.
because if the habeas was denied, then the motion to quash would have been denied as well,
Maybe.
right? It's the same issue, and when I do
Same
file a
judge,
motion to
right?
quash on these issues, it's just the same thing as the habeas, except motion to quash. Administrative differences encourage game playing. I can find a reason to make a constitutional challenge to any statute in the book. But I don't do it because while it wouldn't be frivolous, it's not a productive use of my or this court's time. And so if the rule were that Ms. Couch, I'm sorry I'm over time. I think may I have some of the time that thank you. If the rule were that Ms. Couch has to challenge every part of this count, which should be separate counts, but okay, if we had to challenge both finance and intent to finance, I've got an argument for challenging finance. And it'll get me into court and everything will be justiciable, but it's just silly. It's silly to require the state to play games to prevent justiciability. It's silly to require us to play games to cause justiciability. For those reasons, would you please reverse the ruling of the Court of Appeals and then grant discretionary review on the substantive issue, which is this thought crime. Thank you very much.
Thank you, counsel. The cases are submitted.